Hello everyone, welcome back to our channel U.S. Immigration. We hope you're doing great. In this video, we will talk about Form I-130, explain navigating the I-130 process eligibility, timeline, costs, and more. Navigating the U.S. immigration system can be complex, especially when it comes to Form I-130, the Petition for Alien Relative. This form is a crucial step for U.S. citizens and lawful permanent residents seeking to bring family members to the United States. Understanding the eligibility requirements, the process timeline, and associated costs is essential for a smooth application experience. In this video, we'll break down everything you need to know about Form I-130, from determining if you're eligible to submitting your application and preparing for the next steps. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. USCIS Form I-130. If you're looking to help a family member obtain a green card, the first essential step is to complete Form I-130. Officially known as the Petition for Alien Relative, this form is a critical component in the U.S. immigration process, signaling to the government that you have a relative who qualifies to apply for permanent residency in the United States. However, it's important to understand that submitting Form I-130 is merely the beginning of a multi-step process that eventually leads to your relative's green card. What is Form I-130 used for? Form I-130 serves as a formal request for U.S. citizenship and immigration services to recognize a familial relationship between a U.S. citizen or lawful permanent resident and a foreign national seeking to immigrate. This petition is crucial because it establishes that a legitimate family connection exists and demonstrates the petitioner's commitment to supporting the relative financially. When it comes to marriage-based green cards, Form I-130 plays a pivotal role in proving the authenticity of the marriage. For instance, if you're petitioning for a spouse, you need to provide evidence that your marriage is legally valid and not a mere arrangement for immigration benefits. Supporting documents may include a marriage certificate, joint bank account statements, insurance documents, and photographs together, all of which help substantiate the genuineness of your relationship. Additionally, filing Form I-130 determines your place in line for a green card for immediate relatives, spouses, parents, or unmarried children under 21 of U.S. citizens, and the wait time is typically shorter as they are not subject to visa caps. Other relatives fall into various family preference categories, with wait times based on their priority date, which is the date USCIS receives the I-130 petition. Required documents for Form I-130. To successfully file Form I-130, you must include several key documents to support your petition. These generally include proof of U.S. citizenship or lawful permanent residency documentation such as a birth certificate, passport or naturalization certificate for U.S. citizens, or a green card for permanent residents, proof of a legally valid relationship, marriage certificates, birth certificates or adoption papers demonstrating the relationship, and proof that the relationship is genuine. Additional evidence might include joint financial documents, photographs, and affidavits from friends or family. Proof of name changes, any legal documents showing name changes for the petitioner or beneficiary. Proof of nationality, this is particularly important for the beneficiary, including birth certificates or national identity cards. Handling missing documents. If some required documents are missing, you need to provide secondary evidence. For example, if a birth certificate is not available, you should submit a letter from the relevant authorities stating the document's unavailability. Other acceptable secondary evidence might include baptismal records, school records, or affidavits from relatives. Submitting incomplete petitions can lead to delays or even denials. If USCIS requires additional information, they will issue a request for evidence, which can prolong the process. Therefore, it's crucial to ensure that all required documents are included when initially filing Form I-130. Understanding I-130 processing times. Processing times for Form I-130 can vary based on several factors. Location of application. Processing times differ if the petition is filed from within the U.S. versus abroad. Relationship to the U.S. petitioner. Immediate relatives often have faster processing compared to those in other family preference categories. As of 2024, processing times are approximately, for those living abroad, 11.4 to 15 months. For those living in the U.S., 10 to 23 months. Immediate relatives living abroad, 29 to 40 months. And immediate relatives living in the U.S., 29 to 40 months, if adjusting status via Form I-485. Form I-130 costs. The fee for filing Form I-130 in 2024 is $675. This fee is non-refundable. Even if your petition is denied, payments can be made by check or credit card using Form G-1450. Checks should be payable to U.S. Department of Homeland Security. For those sponsoring multiple relatives, separate Form I-130s must be filed for each person. Eligibility for filing Form I-130. U.S. citizens can file Form I-130 petitions for their spouses, children, parents, and siblings, while green card holders can only petition for their spouses and unmarried children. The petitioner or sponsor must establish a legitimate family relationship with the beneficiary, who is the relative seeking the green card. However, there are certain restrictions and ineligible categories, including extended family, grandparents, grandchildren, nieces, nephews, and cousins, certain adoptive relationships, adopted children over the age of 16, or children adopted after becoming a green card holder, spousal and marital issues, situations involving marriages that were not physically present at the ceremony, or marriages during immigration court proceedings. What happens after I-130 approval? Approval of Form I-130 is just one step in the immigration process after approval. Immediate relatives can apply for a green card immediately if a visa is available. Family preference categories must wait for a visa to become available based on their priority date and country of origin. If the relative is in the U.S., they may file Form I-485 application to adjust status to transition from a temporary visitor to a permanent resident. Additionally, Form I-864 affidavit of support may be required to demonstrate financial support and prevent reliance on government assistance. Understanding Form 130 is a significant step in reuniting with your loved ones in the U.S. by familiarizing yourself with the eligibility criteria, processing times, and potential costs. You can better prepare for the journey ahead. If you have any questions or need further assistance, consulting with an immigration attorney can provide additional guidance tailored to your specific situation. Stay informed, stay prepared, and take each step with confidence as you work toward bringing your family together. That is all for today in this video. What are your thoughts on this? Please let us know in the comment section below. Thanks for watching the entire video. Hopefully the information is useful to you. I'll see you later in the next video. Till then, take care.
Hello everyone, welcome back to channel US Immigration. We hope you're doing great. In this video, we will talk about Form I-130, explain navigating the I-130 process, eligibility, timeline, cost, and more. USCIS Form I-130, the Petition for Alien Relative, is a key step for US citizens and lawful permanent residents seeking to help a family member obtain a green card. This form establishes the existence of a legitimate family relationship and indicates the petitioner's commitment to supporting the relative financially. However, the submitting Form I-130 alone does not grant any immigration benefits. It is just the beginning of the process. Form I-130 is used to prove that a family relationship qualifies a relative for US immigration. For marriage-based green cards, this includes proving the marriage authenticity through documents such as marriage certificates and joint financial records. The petition also determines the petitioner's place in line for green card with immediate relatives, spouses, parents, unmarried children under 21, typically having shorter compared to those in other family preference categories. Key documents required with Form I-130 include proof of petitioner's US citizenship or permanent residency, evidence of a valid family relationship, and proof that relationship is genuine. If certain documents are missing, secondary evidence such as affidavits, alternative records must be provided. Incomplete petitions can lead to delays or denials, so accuracy is crucial. Processing times vary based on applicant's location in relationship to the petitioner. In 2024, processing times range from 10 to 40 months depending on whether the applicant is in the US or abroad and their family preference category. The filing fee for Form I-130 is $675, which is non-refundable. Eligibility to file Form I-130 includes US citizens petitioning for spouses, children, parents, and siblings, and green card holders petitioning for spouses and unmarried children. Certain family members such as grandparents or married children are not eligible. After Form I-130 approval, immediate relatives can apply for a green card right away, while others must wait for a visa to become available. For those in the US, Form I-485 application to adjust status is used for this purpose, along with Form I-864 affidavit of support to demonstrate financial capability.